Starting us off tonight is Preet Bharara. He's the former U.S. Attorney for the Southern District of New York. It's great to be here with you. You've been in these courtrooms. You know what it's like to have this strategy.
From time to time.
So let's just start with your big takeaway from the events of today.
Look, I think it's important to take a moment, like you did in your intro, to consider what an extraordinary situation this is. After all the delays, after all the whining, after all the motion practice, with 3 of the 4 cases delayed, some because of the Supreme Court, some because of an ethics question in Georgia, you have an actual criminal case that's proceeding. You might say you have finally, eventually, the peaceful transition to accountability, which is not a small thing. You have literally a defendant with Secret Service agents to protect him in tow in a Manhattan courtroom in state court, facing the music, and also finding it reportedly so mundane, or maybe he's so tired from preparation that he closed his eyes and apparently maybe fell asleep. That's a big deal, you know, because people have been concerned that accountability is not forthcoming. It is here, and you know, he was the former president of the United States, commander-in-chief. He may be again. He's aspiring to that again, but he couldn't hide in some oligarch's cabin somewhere. He doesn't have his own army, and the fact that he can be brought to justice in the United States of America, notwithstanding his former standing and his potential future standing, I think says something good and right about the rule of law.
Yes, the slow wheels of justice, but they started today, and we can feel good about that. I went through some of this, and I think a lot of us are trying to figure out what to make of it. I mean, because there was a lot of discussion about what evidence was admissible and what evidence was not. So I want to go through some of that and just see how it struck you. The Access Hollywood tape I mentioned. So they can't play the tape, but they can use the transcript. Why, and what does that mean?
So that's a good question, and I have the same question. It's a little bit peculiar. I mean, one thing you have to realize that in all cases, but certainly in a case that the whole world is watching and scrutinizing, and will be especially scrutinized by an appellate court if there's a conviction here, is that the judge wants to tread carefully and make sure that his rulings are sound and within his discretion, and he's never found to have abused his discretion. And you know, one could have argued, I think not poorly, that the entire Access Hollywood business should not have come in.
At all.
You could make the argument, Trump's team made the argument, even though it's probative, for the idea that they were so freaked out by this tape that came out, they wanted to quell, you know, disclosure of this relationship, so they made the payoff. I think a judge could have decided not to let that in for fear of that being something that was reversible on appeal. What I don't understand, and I think lay people and lawyers alike don't fully understand, is, you know, what is the prejudicial difference between allowing in the transcript and every single word that was uttered versus the tape? In fact, because the tape itself doesn't have, it's not a videotape of Donald Trump, it's an audio tape. So they have one but not the other. I'm not sure why that makes a lot of sense.
I guess I feel better that there's not a clarity of answer there.
He was giving one, he was giving one to the defense, and the record will show, and we'll go through some of the other things you might ask me about in a second. When a record shows that a judge seems to be going down the middle and finding in his or her discretion, for the prosecution sometimes, for the defense sometimes, that sets a record on appeal of showing that this person wasn't single-mindedly trying to screw the defense or screw the prosecution or vice versa. So I think it's a reasonably good record so far.
The other piece, and it was the Michael Cohen of it all, which feels like the Michael Cohen of it all could be a theme of the next several weeks, where some testimony on guilty plea was allowed, but they can't imply Trump is guilty just because Cohen was, which again, to a layperson and a non-lawyer, you're thinking, wait, Michael Cohen went to jail for this thing that Trump actually participated in. How is that not the case? And how is that not admissible in court?
Well, the fact that the guilty plea is admissible for other reasons, but it's long been a black letter law that just because someone else in a conspiracy has pled guilty to something, you don't want that to be imputed to the person who's on trial, right? You have to separately prove in a separate proceeding with separate, trial evidence and separate witnesses that the person who's on trial is guilty. But it does have arguably some spillover effect because jurors, although it can't be argued to the jury, jurors will say, well, wait a minute, you have a nucleus of facts about which this other person was convicted and found guilty in some other court. That means that a crime was committed, and they might think this maybe applies to Trump, but they're going to be I think, instructions to the jury that they can't consider that for that purpose. And the judge rightly determined under the law that you can't consider that for that purpose. But it's a double-edged sword, right? Because on the one hand, maybe it's helpful to prosecutors because some guy was convicted of a crime that maybe proves that there was a crime. On the other hand, there's a witness who was convicted of a crime. And among the crimes he was convicted of was lying. And who are you going to believe now? This lying witness who was convicted. So I think it's a big question about how Michael Cohen will be perceived.
I mean, Donald Trump had the sex the hush money was paid for. As an average non-lawyer person, as how I read it. But we'll see how this all plays out. I want to ask you about jury selection. That was obviously a big part of the factor today. You have been a big part of jury selection in the past. There's a lot of strategy involved here. There's a couple things that happened that stuck out. I mean, half the first panel of 96 prospective jurors was dismissed after they said they could not be fair and impartial. They could have lied. Maybe they're being honest. Of course, that's a good thing. There's also a jury questionnaire that was lengthy and asked a lot of questions about people's media consumption. Did anything stick out to you about the questionnaire or the number of people who recused themselves today?
I think it's a down-the-middle questionnaire. I think, most of the questions of the 42 were agreed upon by consensus by both the prosecution and the defense. There's a subset of questions that there was no agreement on, and the judge, I think, made a good determination about what those questions should be and how they should be phrased. You don't usually see scores of people in the first round say they can't be fair. And you said something a second ago that I think is worthy of further comment. Presumably there are dozens of people in the jury veneer in the pool who don't like Donald Trump, don't want him to become president, could have decided, well, I'm going to sort of fake my way into the jury, say I'm going to be fair, and be part of the process that convicts Donald Trump, because maybe it'll hurt him some way politically or otherwise. And they didn't do that. And the fact that you have such a significant number of people who decided, I'm not going to be part of something that's not appropriate, I'm just going to, absent myself, I think is a good sign about the potential fairness of the trial. Yeah,
that's interesting, and a very interesting take, so I want to talk to you about it. There's a ruling next week on the gag order, and I think the gag order, it's this big question of like $1,000 for each tweet. If they're not going to put him in jail, which seems unlikely, is that really going to prevent him from attacking people in this case he shouldn't be attacking, like the judge's family, people? What do you think?
I think the gag order is a little bit of a sideshow. There's not a lot of teeth in the gag order. Donald Trump, it would be a big deal for the judge to put Donald Trump in prison for a day or 2 days or 3 days. So he comes up to the edge, crosses over it a little bit, sips a toe over it. I think the real main show is the evidence that's going to be presented at trial. And I think, it's a difficult thing to be a juror in this case. So that if Donald Trump steps over the line with respect to jurors, which I think he won't do, he's not that stupid, then you'll see, I think, a conflagration. But when he does this sort of, parrying and making fun of people around the judge's circle or the court, which specifically he's allowed to do, I think he'll get away with it.
Hey everyone, MSNBC has a new and improved app. You'll get real-time alerts and analysis, live blogs, in-depth essays, video highlights, and the best 2024 election coverage. Download the new MSNBC app. Here's how to do it. You tap on the App Store on your phone. You hit search on the bottom right corner. You type in MSNBC. You click on the MSNBC app. You click on Get or the cloud icon and enjoy it.